This attorney kept making objections over and over and over again during trial. Why would an attorney, an opposing lawyer, make repeated objections despite the fact the judge kept telling him to sit down and kept overruling his objections? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, in a medical malpractice case that goes to trial, now, there are many witnesses who are going to testify. There will be medical experts. There will be the injured patient. There may be family members. There may be witnesses from the hospital. There will be the doctors whom you have sued. Now, during the course of trial, there are instances where an attorney will jump up out of their seat and yell out, "Objection, Judge!" And now the attorney has to articulate to the judge in a very precise way why he believes that something is improper. Maybe it's a question that I asked. Maybe it's a topic. Maybe it's something that I shouldn't be asking. Whatever the problem is, this attorney feels that I'm doing something improper, and now he wants the judge to make a ruling on it. He wants to stop the witness from talking about something. He wants to stop me from asking a particular question. Whatever the reason is, he makes an objection. The judge now rules on that. And now, 2 minutes later, he jumps up again, makes another objection. And another, and it just keeps going on and on. Now, if you were a juror sitting and watching this proceeding, and now you saw that the opposing lawyer kept making one objection after the next, for what appears to be no valid good reason, especially since the judge keeps overruling his objection, which means that he does not believe that the defense attorney is correct or accurate with these objections. So if you are one of the jurors sitting and listening and watching this during the course of a trial, what is likely going through your mind? I'll tell you what's likely going through your mind. Number one, why is this lawyer doing this? Number two, why is he trying to prevent the witness from answering these questions? It seems like they're appropriate. And why is he preventing me from trying to ask certain questions? What's he got to hide? What does this lawyer have to hide? What does this lawyer not want to come out? And now it appears, at least that's the perception that some of these jurors may have, is that he's trying to hide something. Now that could be very dangerous for the defense. Why? Because now the tide could turn against this defense lawyer and his client simply because he is overeager, simply because he may think in his mind that it's better for him and his client if he continues to object and throw me off track and now try and do everything possible not to allow this witness or this doctor to answer these questions. That may be his thinking, but it may backfire. Just because the defense attorney has a legal right to make these various objections and to make them often and to repeat them, and even though the judge refuses to go along with his objections, do you think it makes a great strategy to keep doing it over and over again to the point where it's really annoying? It's annoying to the judge, it's annoying to the witness, it's annoying to the attorney, it's annoying to the jury. Now that's the biggest danger. Now all of a sudden, things can backfire on you just because you were persistent, meaning you, the defense attorney, was trying to be persistent and show that you were tough and standing up for your client's rights. Well, in my opinion, that's not a great strategy. I have found that some of the best trial attorneys in New York tend to be ones that make objections judiciously, meaning they are very careful with when and what objections to make. There are some objections that, yes, you can make because they should be made. But then again, should they? Really? No, not every objection needs to be made. That's the point. And you don't want to be seen like a yo-yo jumping up and down repeatedly and having the judge yell at you repeatedly because the judge is not tolerating your objections anymore. There's only one instance that I can see that this strategy might be used effectively. And when is that? That is when the defense attorney recognizes that his case is going south really badly, meaning that he's losing his case, that it's obvious to everybody in the courtroom that his case is going down, and that there's a very, very good likelihood that this jury is going to side in favor of the injured patient. In that instance, he may feel he has no choice but to do everything possible to try and create appealable issues, meaning that since he knows he's likely going to get a verdict against him and his client, he wants to make sure that there are a number of different issues that can be immediately appealed because if he fails to preserve those issues, meaning if he fails to make certain objections at the time that they are occurring in trial, if he later goes to appeal that verdict, guess what? And he tries to do it based upon something that happened and he did not make an objection about, then the higher court, the appellate court, will turn around and say, hey, were you sleeping? Did you not recognize that this was a problem during the course of trial? Why are you only raising this issue now on appeal? In that instance, the appellate court, the higher court, would reject his appeal because he did not lay a groundwork and make the objection at the time it was happening during trial. So that may be an instance or a strategy for why the defense attorney keeps making these objections over and over and over again, because now he wants to preserve his right to actually appeal on these various issues. And if he does that, at least he's confident knowing that if he has to appeal the case, it shouldn't be an issue. He won't be rejected simply because he didn't raise these points during the trial, during the time it was happening. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.